Hello, welcome everyone to the Stringer LLP webinar. Jeremy and I, my partner Jeremy Schwartz and I are kind of in the hot seat today. We tried to put together a webinar. Like we as labor and employment lawyers, we've spent an incredible amount of time in the last month or two talking about vaccines and proof of vaccination and vaccine policies and how this interacts with various aspects of employment law and occupational health and safety law, and in some instances, labor law. So where we're at today is Jeremy and I would like to go through the material with some efficiency so that we have time for questions. You can insert your questions in the usual manner through the question chat box on the GoToWebinar software. And this will give you an opportunity to, just fire your questions at us, and we'll take as many as we can with the time that we have. We have historically had some really good and interesting questions on these sessions. I think everyone will kind of benefit from them. But to give you a roadmap of where we're going, and for those of you who don't know us, we are a labor and employment law boutique firm practicing out of downtown Toronto. Much of my practice is in the area of occupational health and safety, workers' compensation, and human rights law. Jeremy practices in those areas as well, with a particular focus on labor relations. So without further ado, we're going to go and start with what I can only describe to be as one of the most bizarre policy decisions and policy structure I have ever seen, even though I've been practicing occupational health and safety law now in Ontario for more than 20 years. The Ontario government has amended the regulation, the COVID-related regulation 364/20. And this is it's really just one of the strangest things that it almost feels like the most obscure law school exam question that could ever be asked. Essentially, rather than having just a provincial mandate under provincial health legislation or even the Occupational Health and Safety Act, as far as employers are concerned, the province has essentially punted legal compliance around the issue of vaccine policies to chief medical officers of health in each local public health unit, which doesn't necessarily correspond in all cases to specific regional breakdowns, county breakdowns in Ontario. So you'll have to look at what region you're in, and for some of you who operate multiple facilities, you could be in any number of public health units across the province of Ontario. And so what the government has done is, as a part of health legislation, they are requiring employers to comply with any advice, recommendations, and instructions issued by public health officials about vaccine policies. And this is the part where, as a lawyer that obviously that really surprises us the most, I've never heard of being legally bound to follow something that is a recommendation. That is a very tricky, unusual, bordering on unprecedented situation as far as I've never seen anything like it, where the government makes a recommendation either by way of a public statement or in a guideline or in public health advice to say that you're legally bound to follow it and potentially prosecuted if you don't. So the bottom line is that there's a strong interpretation to say that employers are legally bound to follow the advice that the public health unit has issued. We could put our lawyer hats on and start, parsing some of the issues about what if the recommendation was made before the regulation came out? If the regulation had a retrospective effect, although retroactive effect? These are all things that you hope you never have to retain us to answer if you're in court. But suffice to say, the answers aren't crystal clear on that question. So I think that the general advice is that you want to follow what the recommendations are in your local public health unit. All of those are available online, and they do vary, frankly, in what they look like. Okay, most of them have most of them aren't a strict "you vaccinate everyone" policy. We'll get to one that almost looks like that. But most of the recommendations recommend that employers have a vaccination, that they must have a policy that basically employees are to be vaccinated subject to human rights exemptions. And for those who don't, they often say that there should be some sort of alternative regime around personal protective equipment, around social distancing, and around regular COVID-19 testing. And there are different approximations of this, and I'm not going to pretend that we can go through each and every one of them for you here. But I did want to draw attention to one policy in particular in London Middlesex, which of course is the city of London Ontario and certain surrounding municipalities in southwestern Ontario, one of the bigger municipalities in the province outside of the GTA in Ottawa, has issued strongly recommending a directive, strongly recommending that all employers, business officers, or operators implement COVID-19 vaccination policies, requiring employees, volunteers, and contractors who have in-person interactions to be vaccinated against COVID-19, subject only to human rights exemptions. That is basically saying almost everybody has to be vaccinated unless you can establish a human rights exception. And Jeremy, in a moment, is going to go through with you what those human rights exceptions are, what the courts and tribunals have said about them, what the Ontario Human Rights Commission has said. All that is interesting, and we'll get that to a moment. But if you're in London Middlesex, it's basically saying if you have a situation where someone who has in-person interactions, which, I mean, unless you're working alone, I think by my read of that language is you have in-person interactions, there's going to have to be that policy. As I noted before, a strong recommendation is not usually the word that the legislatures in Ontario and elsewhere across this country, and frankly across the common law world, use when they're trying to have something that's enforceable and mandatory. The kind of words we see are words like shall or required, the commonly understood terms to say you must do this or you are in violation of the law. How this would shake out if someone was ever prosecuted for refusing to have a vaccine policy is of interest to lawyers. And there may be a wiggle room or a defense to say that, well, it's a strong recommendation, even though the regulation says comply with recommendations, you have to take the ordinary term of what a recommendation is. And all of these things would cause us to get out dictionaries and are very interesting to lawyers, but frankly, they're not interesting to you. And that would be an expensive fight. And I don't know, frankly, how much sympathy a court's going to have, particularly where most of these health units aren't requiring the type of aggressive policy that London Middlesex is. They're just basically saying, thou shalt have a policy and giving you a fair bit of wiggle room as to exactly how it works. And of course, some of the municipal, the public health unit directions have suggestions for those that refuse to get vaccinated, requiring them to view what is considered to be, at least by the public health authorities, to be educational material on the merits of vaccinations. So how does the Occupational Health and Safety Act fit into all of this? The Act doesn't explicitly address this issue. Those public health orders are not issued under the auspices of the OHSA. The OHSA, though, does include the General Duty Clause, sometimes referred to as the Bucket Clause in Section 25 sub 2H of the legislation. The legislation requires employers to take all precautions reasonable in the circumstances for the protection of workers. One can argue that there have been many Ministry of Labor prosecutions over the years based upon an employer's failure to comply with a particular standard, even though that standard isn't explicitly referenced in legislation. These are things like CSA standards. These are things like sometimes Ministry of Labor guidelines around forklifts, that kind of thing. So one could surmise that there could be a prosecution from the Ministry of Labor based on the failure to follow municipal directions, although one would assume such a prosecution would more likely come out of the public health union as opposed to the Ministry of Labor, but that can happen. I'm also going to say, take it as an aside to note that the Toronto Star has reported that there has been the first prosecution, significant prosecution. I mean, there have been some minor ones in relation to fatalities arising out of COVID-19. This was an event that took place involving migrant workers and on a farm. The allegations are, of course, have not been proven in court, and those charges have just been filed. So that's the first significant piece of Ministry of Labor-related litigation as far as prosecutions go in relation to this. There have been, some minor tickets issued to people and such, but things like violations of social distancing in retail settings and such. But this is the first serious prosecution that has arisen under that legislation. So that's an aside. So the next slide I just wanted to look at, and we've talked a little bit about this before, but I think it's a reminder of how things are likely to be approached in litigation for those who are interested in challenging COVID-related restrictions and rules. This is not in the context of vaccination. It's an early case dealing with masking, and this was at the Labor Board, and the board sort of spoke about what they call a precautionary principle. The board says that they recognize that COVID is a dynamic and evolving situation. Even more than a year and a half later, that's still true. Information on how to best control the virus is subject to constant revelation and possible change, but reasonable precautions must be taken. And basically, the board says, look, at the present, at the time of the decision, it clearly appears that the risk of masking outweighs the risk of not masking. So applying that kind of reasoning to the vaccine situation, a much more intrusive issue than masking, of course, in terms of you're talking about fluids into someone's body, violating a person. But basically, that you can see that there's certainly a logic that seems to have been taken by regulators and the labor board to say, look, that we're going to go with the science, especially in context of COVID. So that weighs upon the side of more restrictive requirements around vaccines. So I'm going to turn it over to Jeremy, who's going to shift the discussion to how human rights code issues affect these matters.
Thanks, Ryan. So if you're like me in your practice as human resources professionals, you will have seen your first of many exemptions that have come in from employees claiming that they don't have to vaccinate, or that they don't have to wear a mask, or that they don't have to follow certain other protocols in the workplace that have been put in place from time to time, either by employers or public health, and relying on an exemption, allegedly, under the Human Rights Code in the jurisdiction in which they're working. The definition of a disability, which is the primary place where we're likely to see a valid objection to vaccination, at least in Canada, based on sort of what is known anecdotally and from prior case law, is based on a disability. So a disability is defined in the regulations and in the legislation. It's not just this term that's at large, okay? And so each province has their own human rights legislation, their own definition of disability, but they're all relatively similar. So if you've got a diagnosis from a medical professional, such as a doctor or a nurse practitioner, where they have diagnosed you with a medical condition, then that might be a disability if by virtue of that condition, it has an impact on your functional abilities in the workplace within the meaning of the Human Rights Code for our purposes. The Ontario Code begins with talking about sort of the mental and physical disabilities, and it lists a whole bunch of examples, not intended to be a complete list. And it also lists, which I think is very important for employers to remember, that if an employee commences a claim for workers' compensation benefits, that is defined as a disability. So even if the employee doesn't get their claim approved, you cannot commit a reprisal in respect of an employee's claim for workers' compensation related disability. So that's just something as an aside to keep in mind. But generally speaking, a disability is a disability. You know it when the doctor confirms it. And the question about whether the employer has the right to know the diagnosis usually lands on the side of the negative. But in almost all cases, the employer will have the right to more than just person can't wear a mask for medical reasons. You might actually be entitled to a little bit more information, such as what are the physical restrictions, or what are any other accommodation options, so that you can assess whether you can do something instead of imposing the mask or vaccination requirement. Excuse me. The Human Rights Tribunal and courts across the country have interpreted the term disability very broadly. But speculation about whether vaccines are safe is not a disability, right? Your fears, or an individual's subjective fear about what's in a vaccine, that they don't know what the ingredients were, that's not a disability. That fear is not a disability. So as an example, in Toronto, when they issued in Ontario rather, as of September the 21st, there's a requirement for non-essential services in certain locations for people to bring proof of vaccination and proof of exemption from the proof of vaccination requirements. And the Toronto public health authorities made it clear that they're only going to be accepting essentially 2 exemptions, at least from the disability side of this. The first side of that exemption is going to be that someone has an actual disability that prevents them from getting the vaccine, which could be certain heart conditions have been identified. And on the other side, someone who had sort of a first vaccine, for example, or already has an allergy to the components of the vaccines. And so there are, in very rare cases, as confirmed by the doctors who have been looking at this, very rare cases where people will have a valid medical condition that would exempt them, okay? And these sort of vague medical studies that talk about how these are unknown and the nonsense that people have read on social media, none of that's going to be acceptable as proof of an exemption. You're going to need something from a medical professional, either a doctor or a registered nurse practitioner, or for example, an allergist confirming that you are allergic to the components and you may suffer a severe or even anaphylactic reaction. Now, the College of Physicians and Surgeons has given advice to doctors. So they've, of course, had a flood. There are a number of doctors who have been even calling the police because outside of their doors, they have people lined up to get, essentially trumped up invalid medical certificates confirming that it wouldn't be safe for them to get vaccinated. And of course, that advice from Toronto Public Health is the same for all people, even if it may not apply to them automatically, which is that it's only in very rare cases that a valid medical exemption will arise. And so the doctors have been instructed essentially by their college not to just be handing out vaccination exemptions to folks who really don't have a valid exemption. And the intent, of course, is clearly to ensure that doctors not willy-nilly be issuing these things. They don't want employees thinking their doctor will give them this sort of standard, I don't feel like going to work yesterday note. And the critical piece here is that as a result of that, it's likely that we're going to be getting a number of other kinds of exemption requests. And the first piece, when it comes to vaccination policies, and I'll talk about religious exemptions in a moment with reference to a case, but the Human Rights Commission in Ontario has provided some guidance. It's actually fairly middle of the road for the Human Rights Commission in my view. They've outlined a number of considerations, but they haven't said, which I have to say as employers counsel, I was a little concerned they might go this way. They haven't said that a vaccination policy in general is going to be unlawful or violate the code. They haven't said that testing in general will be a violation of somebody's core essential human rights. And I contrast that with, I just did a program recently for Bongard where I presented on workplace substance abuse. And I talked a little bit about testing in the context of drug and alcohol intoxication while at work. And the law on testing as it applies to drug and alcohol use while at work is night and day when it comes to the way the courts, the tribunals, the arbitrators, even the Human Rights Commission have been viewing the obligation to submit to a test for access or in order to be employed in a situation where other people may be placed at risk. Which, I mean, again, the idea that that same analysis doesn't hold true for some reason, and that it's such a privacy invasion to submit to a cotton swab for a drug test, but somehow not to a cotton swab way up to the back of your brain for COVID. Somehow these are not the same privacy infringement. Somehow the health and safety consequences are weighed differently. But suffice it to say, not even the Human Rights Commission has said that where someone is not being vaccinated for valid human rights reasons, that they can also say, I'm not going to get a test, unless, again, there's a valid human rights or medical reason why they can't submit to the testing based on the way that it's conducted. So in general, having a policy which contains the you must get vaccinated or else you must test and wear a mask, and possibly if you follow the Toronto Public Health or other recommendations from chief medical officers of health, an educational session for employees who don't want to get vaccinated. These are all things that under the code in general will be permissible. Now there is this issue of religious exemption. And first let's talk about this. Religion doesn't just mean the big faiths, the ones that you think of instantly when someone talks about the religions that are sort of commonly throughout the world and in Canada. There are many subsects of different religions. Someone's creed is often protected under the code in the same way that their religion is. And so the critical issue is going to be, is this an honest and deeply held belief that is the tenet, one of the tenets of somebody's faith? And so in general, I'm not aware of, personally, I'm not aware of any religion that expressly says you can't have a vaccine. Okay, so let's start with that. There are some faiths which deal with putting foreign substances of different types into your body. Some faiths have determined that those prohibitions mean they can't drink alcohol, for example. I have seen a number of, I have to say, the most bizarre affidavits notarized by employees or by their spiritual leaders from whatever church or association they belong to, claiming in the most bizarre language that their faith and a central tenet of their faith is that they have the freedom to determine whether or not to put something into their body. So the question, of course, is, well, having the freedom under your faith to determine, or whether your faith prohibits, those are two different things. And that's something that ultimately the human rights tribunals are going to have to work their way through. It's a question of whether it is a matter of conscience or a matter of religious tenet or creed. And that's something where, do you really want to be at the tribunal splitting the hair on this? The bizarre, again, affidavits that I have seen, my partner sent me one the other day where there were 3 pages of discussion of all the general political and nonsense reasons why. They read one study that says it's unsafe or whatever, but then the final page said, with references to a number of parts of their scripture, why they believe it's a central tenet of their faith not to have this vaccine. And so, is it possible to challenge that at the Human Rights Tribunal if you deny that exemption and then you get sued for taking action as a result? It's possible. But is it also possible that that will be accepted by a Human Rights Tribunal as a valid religious objection and exemption? Yes. Now, does that mean this individual doesn't have to get vaccinated and there are no consequences? Absolutely not. That's not what accommodation means. So you may not be able to require that individual, if they have a valid medical or religious exemption, to get that vaccine. But you still have to take all precautions reasonable in the circumstances for their protection and the protection of others. You still could face liability if they interact with members of the public. You know that they're unvaccinated and there are not protocols in place to protect them and the people visiting from the public. You could get sued by a third party for not taking reasonable precautions or for being negligent, depending on the level of negligence that we're talking about in your particular jurisdiction. For example, in Ontario, it's not enough to be simply negligent. You must be reckless, essentially, before you can be sued for a third party getting COVID through transmission from your facility. But in other provinces, it may be different, and we still don't have case law on the way that that is being reviewed. Now, this was a case that happened last year. The situation essentially was that an individual complained about the City of Toronto's masking requirement. The masking requirement in Toronto said that everybody has to wear a mask to go into an indoor location, which included stores, restaurants, all of the above. But that an individual could say that they have an exemption and they weren't required to prove that they had an exemption. And so that was the weird twist, and everyone complained about this, and this was much abused, at least in my view, in my experience. But the law said that if someone told the business owner, I have a valid medical exemption, or it's contrary to my religious beliefs, then they would be allowed to go in without wearing their mask, and other precautions could be taken. In some cases, that would be the only person in a particular space, ensuring social distancing and sanitizing, and ensuring that they're not in close contact with anyone would be important, of course. But this individual didn't bring a claim against the business that gave them a hassle when they tried to enter. Instead, this was an individual who said the City of Toronto has violated their human rights, both on the basis of a disability that they had and on the basis of their creed, because of the hassle they say that they faced going into these various establishments. They didn't name any business in particular. They went after the city. And so the Human Rights Tribunal took a look at this and they said, well, number one, the disability was valid. So that's not really coming out of the case in particular, but because the city's bylaw exempted individuals from being required to show proof of that exemption. And because the application was brought against the city for its bylaw, but not against individual businesses, that wasn't something the tribunal could adjudicate. If the tribunal did say if this claim had been brought against a business, that might have been a different story. On the other hand, with respect to creed, what was really clear from the complaint was that this person felt that this was at least an unpalatable requirement, that it was unfair in some ways, that it bordered on quote unquote communism and all this other nonsense. But none of these flowed from a deeply held bona fide belief that arose from a creed or their religious followings. And so as a result, there was no religious exemption to the city's bylaw as a basis for saying, I don't have to wear a mask when I go to a restaurant, essentially is what happened here. I'm not aware of any other cases where someone went this far and got a tribunal decision, which essentially just said, this is nonsense. We're not going to deal with it. It's a very brief decision dismissing this complaint. Now I'm going to pronounce this wrong, but in Atelhai and Lambton County, there was an EMS, a paramedic who complained, and this is back in 2011, and we were dealing at the time with flu shots. So paramedics were required to get flu shots, or else they weren't allowed to work. They would be placed on a leave of absence an unpaid leave of absence, until they got vaccinated or the sort of flu season came to an end. And this individual complained that other healthcare workers didn't have to wear them, that the medical evidence between getting the vaccine versus wearing a mask and following other protocols wasn't proven, was the assertion. And ultimately, it came down to this: the ground of occupation, so the right to have your job, is not a ground under the Human Rights Code. So this job versus that job, discriminating between paramedic ambulance drivers or EMS technicians within the vehicle versus doctors at the hospital, you can discriminate between different positions of employees. That's not a violation of their human rights. So what again, similar to the Sharma case, this was a situation where this person didn't like that they were treated differently from others, but the different treatment wasn't as between them based on a ground protected or prohibited under the code, such as their disability, their creed, their religion, etc. Instead, this was just a general health concern and preference, and a discrimination which was lawful as between different positions of people. And so it's not the Human Rights Tribunal's job, or a court or an arbitrator's job, to adjudicate the unfairness when it comes to an allegation that the code prevents an employer from doing something when the code just doesn't apply. I think now I'll be passing this over to my friend Ryan to take us through some alternatives for non-code protected cases and work refusals, and then we will get to your questions. Ryan?
All right, thank you, Jeremy. That was very an informative trip through the sort of complicated world of human rights exemptions. And like Jeremy, I've seen also a vast number of letters, and I've become more familiar with the Nuremberg Convention, and it takes me back to my days as a first-year history student in Lakesville, Quebec, many years ago. But nonetheless, I'm hearing a lot of references in those letters that are certainly to somewhat obscure things, at least for those of us who live in the day-to-day world of human resources. So let's talk a little bit about testing. Let's assume for a moment you're not in London Middlesex or another health unit that basically says unless you have a human rights exemption, you're vaccinated. This is a very fact-specific question. It's going to sort of depend upon the nature of the workplace, how many people that are there, how close to contact they work, is it commonly accessible to the public, is it not? We already know that, I mean, we're in sort of the odd situation as it exists with vaccine, with that sort of so-called vaccine passport system in Ontario, where you could very well be going into a restaurant where the customer has to show proof of vaccination, but not necessarily the staff member if there was not a policy requiring it. So I mean, it's a very it's a fact specific it's a fact specific case. But certainly for employees that don't have human rights protection, it could come down to a situation where you decide that you would want to keep this employee, that weekly and ongoing testing is or twice a week testing is an option, and you have them insisting that they continue to wear masking, social distance if they can, and have them engage in testing. And that of course raises the thorny question of who pays for the testing. The Human Rights Commission, which again that Jeremy referred to, the Human Rights Commission being sort of the legal body in Ontario that publishes interpretations of human rights law. They're not actually the decision makers, that's the tribunal, but they have said in human rights cases that the employer should pay for it. Of course, but that guidance, even if it were to be adopted by the tribunal, is not relevant to other situations. There may be some employers that ultimately say that the employee is going to have to pay for it. Because that's much like employees in some places have to pay for their own safety equipment, hard hats and safety boots and that kind of thing. So maybe there's a permissible argument to that effect. So and remembering that, and also what kind of testing are we talking about? Are we talking about the antigen test, which is sort of the rapid test that's commonly available for about $40, or are we talking the more expensive molecular test, the so-called PCR test, which can easily cost $200? The rapid gen test, you can get an answer more quickly. The PCR test takes longer and is far more expensive. That's the one that it's required for admission to Canada, for example, if you're crossing the border for anybody. So these are all the cases. I think that from a due diligence perspective, I think I recommend that any employer considering allowing non-human rights exempted folks to go through a testing process to undergo a hazard analysis and to assess what the risks are before you're prepared to make that decision. I mean, in part, some of that may very well be driven by business. There is, for the first time in a long time, first time in living memory, as far as I know, that there's a labor shortage in North America. So it may very well be that some employers are saying that, well, if we do this, it's potentially in certain sectors, we may not have enough employees. So this is the alternative. And if you're legally permitted to do so by the guidance under the public health union. So one thing I've got to stress also, if you enter into this sort of testing regime, you got to pay attention to what those guidelines are. We all know, as anyone who's had children can certainly attest, the government's, what they say one day, it could very quickly change the next on the basis of scientific or political concerns or whatever it may be. So you got to watch. It may very well be that the public health units all adopt sort of the London approach to say that if you don't have a human rights exemption, you got to be vaccinated. Whether that actually happens or not remains to be seen. Moving on to the next slide here, we are going to be discussing work refusals. So work refusals, again, I've never seen work refusals have been in health and safety legislation for literally decades, especially in non-unionized environments. They don't come up, frankly, all that often, and they're even outside the public sector or even more rarely litigated. But ultimately, there's been a lot of work refusals in the pandemic, very few of whom that have been sustained. So let's take a look at what the provision is here. What happens, for example, if a worker who is vaccinated says, I don't want to work with someone who isn't vaccinated. That isn't safe for me. And would they qualify? This is assuming for a moment that the work refusal provisions apply. In some situations, they do not. But basically, the one that likely comes up is it's under sub B. The physical condition of the workplace or the part thereof in which he or she works is likely to endanger the worker or him or herself. Could one interpret that the physical condition includes someone with COVID? That I don't know. Maybe yes. Maybe no. Or no. Or sub C, any equipment, machine, device, or thing he or she is to use or operate in the physical condition of the workplace or part thereof in which he or she works. So, look, first of all, there's obviously a threshold argument that the work refusal provisions don't apply at all. And to the extent that they do, how is that going to play out? I will say that the Ontario Ministry of Labour has been, not, as I said, in the context of other work refusals and COVID, has been pretty not particularly frequently sustaining these kind of objections. I think that where I will look to, the only jurisprudence I can look to is there is a number of cases, obscure old cases now from the SARS pandemic at the airport, about 20 years ago in the city of Toronto. And those cases are, because the airport is federally regulated, those cases are decided under the auspices of Part 2 of the Canada Labour Code. And then basically in those cases, the decision makers were pretty skeptical of employees that were refusing to work in the SARS context, saying, look, as long as the appropriate precautions as recommended by health authorities are followed, this work refusal is invalid. And I think, again, that's probably what you're going to be looking at here. I think as long as you are complying with the recommended guidelines that have the force of law, that provides a pretty good answer. Unless there's something very specific about your particular workplace that enhances the risk that wouldn't ordinarily be there, that would suggest that other reasonable precautions beyond what are prescribed by the health officer is required. I mean, the bottom line is the courts have recognized, the Court of Appeal specifically has said on more than one occasion that occupational health and safety law, although needs to be interpreted broadly, is not meant to eliminate every conceivable risk in the workplace. It's what the court has said. It sets out a minimum level of protection, and that's what I think that's sort of the mentality here. So I think I think the focus is, I think it doesn't mean to say you're not going to get a work refusal from someone assuming you implement a testing regime. Emotions are running very high on this issue. I don't want to characterize it as sides, but for those that think vaccinations are important and those that not only think they're not important, but frankly dangerous. So this could arise. You're sort of stuck between a rock and a hard place that way from two groups that feel very passionately about this issue. But from a legal perspective, following the guidelines as they are currently set out, and those of course can change, is the best defense to a work refusal, and be prepared to provide your copy of your vaccine policy and to have it on hand and to send it to the inspector from the Ministry of Labour, Skills Development and Training upon request. So those are my comments on work refusals. I just want to leave you with some practical thoughts. One, again, it's complying. Again, it just comes back to the point that we made, that this legislation is evolving at a pace unlike anything I think any of us in terms of public protection legislation have ever seen in modern history. I mean, it's unprecedented, obviously, in terms of the global scope and impact of the pandemic, earlier pandemics, or early sort of public health disease concerns, things like swine flu and SARS had nowhere near the impact this does, obviously. I think that there is a temptation to, it's hard to avoid the fact that the issue of vaccines has become highly political. And particularly in the United States, but it's not to say that that's to be exempt from Canada at all. You want to avoid the politics of it. The law is what it is. These guidelines have been published. They're clearly not, in all likelihood, optional for doing so. So even for those who feel, I think it's not helpful to become angry or argue and debate about those that feel differently about this. They're entitled to that opinion in a free and democratic society. And this certainly wouldn't be the first or last time people have expressed concerns about vaccines. But that being said, that doesn't mean that certain consequences, legal consequences, and employment consequences may flow for employees that don't comply with the law. In the same way, quite frankly, some people may think it's a waste of time to have a hard hat on a construction site. Maybe in some construction sites it is, but absent a human rights exemption, you got to do it. So at the end of the day, that flows into my next comment, is just avoiding fear. Like, ultimately, you may very well end up litigating this. And I think anyone who knows that look, employers are almost always the underdog in any kind of litigation against an employee, the way the law is set up, because of the law's decision that there's legitimately an imbalance in bargaining power. But an employer that's advancing a position that we're complying, setting up a vaccine policy that now, unlike the past, does have the force of law, however sort of obscure and inelegant and variant that it is, even regionally within Ontario and certainly nationally. But look, you're in a better position than you're probably ever going to be in terms of defending your position if you're following, implementing a policy that's required by law. Privacy, we didn't talk a whole lot about this today, but I mean, again, you have there are whole firms and legislation that govern around privacy of medical records. You want to make sure that you keep people's medical information, their proof of vaccine, private, and that you're not discussing it broadly. I recognize the practical reality is that people talk, and particularly someone who's unhappy about being tested every week for COVID is probably not going to be, might be voicing their thoughts on it. But you have certain obligations, and one thing I stress, like Jeremy alluded to, the sort of the kind of exemption letters, and some of them that frankly seem a little bit not well grounded in law, and so in referring to things that are not likely legally meritorious, even though the person who wrote them must feel strongly about them. You don't circulate those. You don't send them out. You don't. It is that's private, and that's not to be circulated. And lastly, I mean, look, I think, dare I say, and I'm daring to hope, I know we're still in the heart of the fourth wave in the Delta variant, but I think we need to keep calm and carry on. I think we're closer to the end of this than we are previously. I'm hoping that Jeremy and I are not going to be talking to you again in a month about this topic. I'm sure that we will be talking about something. Certainly, our firm conference is coming up, and we undoubtedly will be touching on these and a number of other topics. But I'm hoping that at some point that as far as at least the legal consensus goes, it seems very clear to me in Ontario and nationally that in order to work and access many public facilities, proof of vaccination is going to be a requirement, subject to very narrow medical and religious exceptions. So that's the writing on the wall for where I see the world. We wanted to leave a lot of time for questions, and we have. So if Jeremy can just let's see if we have any questions and go from there.
Thanks, Ryan. We do have an awful lot of questions. One question that's come up from a number of folks is just sort of asking if the slides will be available afterward, and also whether the recording of the session will be available. And as always, we will be putting up a copy soon of into our media center on our website of this program, which within probably about a week or so, you'll be able to go and review it to your heart's content, or send it around to colleagues who you think may benefit. And also, anyone who's attended will be receiving a survey through our SurveyMonkey platform, if that matters to you. I don't know if you have any rules that might prevent it from coming through. If you respond to that, you'll be taken to a page where we thank you and provide you with a copy of our slides and other helpful resources following the webinar. So if you keep your eye out for that, you'll get that, if not today, then probably tomorrow. And so now maybe we'll get on to some of the bigger questions that we've got. Let me just go up to the top, see who got their question in first. All right. So Ryan, how about I'll send this one to you. For employees who refuse to get vaccinated, can we use our in-house COVID rapid testing to screen them in order to keep our workplace safe?
Well, I mean, let's put it this way. I mean, the reality is that there is a whole lot of different COVID testing out there, and I don't see why you can't, right? I mean, I think that there's nothing that says that this is the particular COVID test that one is required to use, whether it's a molecular test or a PCR test. I mean, obviously, if it's one that's from an accredited situation, I think you actually have those kind of in-house capabilities, and that's going to be a minority of employers. I think I don't see anything wrong with that.
I think I'll take this one. Will the province have an exemption process for the vaccine passport, and will this supersede an employer's decision for a vaccine exemption? Okay, so let's remember that the vaccine passport, at least for now, as aggravating as it is for every employer in the province, there is no plan that's been announced to link the employment obligations under the Health and Safety Act, or to follow the directions of the Chief Medical Officer of Health in your local area, with the requirement to check people's vaccine passport app when they come in to use your services or to buy your stuff. And so bizarrely, as Ryan said, you might have a requirement to check the passport of someone who's coming to your restaurant, but you may not be able to use the same passport system, or at least it's not clear yet whether you can use that passport system to check whether your employees have both of their vaccines taken. My personal view is, unless the regulations come out once the app is ready to say employers are not allowed to use that as a fast way to confirm without having to get vaccination proof from employees, then that would be the easy way to do it. If employers have access to the app and getting confirmation that way. It would also mean that you don't have to maintain a copy of people's personal medical information, because the app shows you whether it's true, and then you don't look at it again. Like, you don't keep a record of it. So that would be a great way. You could have a little sign-in sheet where you just sign off that you've confirmed on the app. But again, in terms of an exemption, the government has not said yet whether exemptions will be built into the app. For now, people have to bring a copy of a medical note or whatever else it is. There's been a lot of pressure on the government when their app rolls out in the next month or so to include some feature where if there's a valid exemption that's been vetted by health officials, that will show the person as, admissible but exempted, for example. But we don't know yet what that will look like or if it'll ever come out.
Yeah, I'm having my doubts that'll come out. I don't think you're going to likely see a
You're not holding your breath on this
government.
one, are you, Ryan?
Good luck with that.
So I've got one here, Ryan. This is one of the attendees says we have a note for a vaccination exemption, and all it says is due to medical reasons. That's all it says. How do we get to the point of identifying if it is an allergy or a heart condition when considering confidentiality or doctor-patient privilege? So can we get behind? Can we get more? Is essentially what this person's asking.
Well, I mean, and I think in order to answer that question, I mean, ordinarily what you're hitting on is one of the sort of most thorny issues when you're dealing with medical notes. In general, I think that what I'm going to do is just look to the guidelines from CIPSO, which is the College of Physicians and Surgeons, that basically what the College of Physicians and Surgeons says, and this is unique to COVID, I've got to tell you, is that I'm just going to read from the guidance. Given the rarity of these exceptions, and in light of the fact that vaccines have been proven to be both safe and effective, any notes written for patients who qualify for a medical exemption need to clearly specify the reason they cannot be vaccinated against COVID-19, document clear medical information that supports the exemption, and the effective time period for the medical reason, i.e. permanent or time limited. So if you look at the guidance from the college regulator, that medical note does not satisfy that guidance. So I think the way you get behind it is to write back and refer to the guidance and ask the physician to comply with the direction from the college.
Follow your own professional obligations.
Something like that, yes. Mm-hmm.
And I have it on good authority that the College of Physicians and Surgeons and other professional bodies in the medical field are not doing online disciplinary hearings right now, and they have about a 2-year backlog to deal with on top of the backlog they had from before. So obviously you would never threaten the doctor that you'll bring them up on disciplinary charges, but it does not bode well for the discipline within their profession, I would say, to be backlogged to that extent. So an individual has asked a question, talking to a minister recently, they thought Jehovah's Witnesses may have a case for vaccine exemption based on ingredients. I guess what I'll say first off is I know a few people who are Jehovah's Witnesses. They've confirmed for me, at least based on their understanding of their faith, that vaccines are perfectly fine as far as they know. In terms of blood transfusions, for example, that might be a different story. But to my knowledge, Jehovah's Witnesses can get all sorts of vaccines. Again, this is an issue that gets litigated from time to time, but ultimately what you need to do is to follow what the Human Rights Tribunal essentially has said are the basis for determining that that there is a prohibition. And so it needs to be this individual's honestly held belief that a central tenet or a critical or important tenet of their faith prohibits them putting the vaccine into their body. It doesn't have to be specific to COVID-19, but you want to be careful about how carefully you vet someone's honestly held religious beliefs, right? So you do have the right to ask them to provide you with a written statement confirming what faith it is that they're relying on, that confirming that they do believe that it is a central or critical or important tenet of their faith or of their creed, and you may not want to challenge that further, especially certainly not without legal advice.
Yeah, I think Jeremy's right. We all remember that even within subsects of fairly well-known faiths, even like certain Christian faiths, for example, prohibit consumption of alcohol. It's not a mainstream position in Christianity, as far as I understand, but certainly there are some where that is not just a belief, it is a fundamental belief. to the core of the beings of the people that share that type of faith. So I agree with Jeremy. You start really getting very risky if you're parsing someone who really has a set of spiritual beliefs that it's a tough situation.
Right, and I suppose, as Ryan and I have mentioned, we've seen a number of notes in the religious and medical side which don't appear to be, well, not that they're lacking in credibility, but they appear to be saying a number of bizarre things that are irrelevant or unnecessary. But at the core of it, your analysis as the employer has to be: is this a valid exemption? And the valid exemption question isn't, do I believe it's reasonable for someone to have this faith? The question is this their faith? And is this part of the faith that they practice? And if it is,
yeah, exactly. I think when we start seeing things for like, it's just goes back to you kind of know it when you see it kind of thing, referring to that old sort of U.S. Supreme Court comment in the context of what is pornography. In this famous comment from Justice Potter Stewart. But what I really look for is when I start seeing things like reference to the Nuremberg Convention. That's a political or legal argument, not a religious one, obviously.
Right, or when someone is citing some scientific study in the context of their statement that they have a religious objection. I find that bizarre. Again, keep it simple, but only challenge these where there's clearly a lack of a connection between the objection and the centrally held religious belief. I mean, these are important. To Ryan's comment before about not getting into political debates with people, a lot of people feel very emotionally tied to their beliefs on this. And if we're talking about someone's religion, challenging that probably isn't going to end well. Here's a question for you, Ryan, and it sort of jumps off of a question you tried to answer earlier, but I'm going to hit you with it again anyways. Can a worker refuse to work with someone who's not vaccinated on the basis that that unvaccinated person puts them and their family at risk?
Let me try to be as clear as I can on that. I know that there's some of you who are listening to us from outside Ontario. So, and the caveat to this answer is we're referring to the Ontario in the provincial jurisdiction, which around how work refusal works, and that varies from province to province in the federal jurisdiction as well. But in Ontario, I put up the slide of the work refusal provisions. There's an argument to suggest it doesn't apply at all. OHS law is fairly broadly defined, so let's assume for a moment that it does apply. Ultimately, my view is that, and obviously this decision will be made by the labor board someday, because that's where if a work refusal, if a party wants to dispute a finding for a work refusal, and here's how it works. Part one, you try to resolve it internally. If you can't, you get in touch with the Ministry of Labor inspector, who can deal with it in person, or more likely virtually by phone or other such measure. And if you don't like the person that doesn't like the Ministry of Labor inspector's decision about whether the refusal is valid or not, can then take the matter, or the union can take the matter, if it's a organized workplace, to the labor board. So in my view, what I expect the board will do is if the fact pattern is that the employer is following the guidelines applicable from the public health unit where the employer is located, and there's nothing very specific or unique about that particular workplace that would grossly increase the risk, and there's a precaution that ought to be being taken, and it has to be like a very specific kind of situation, I think the chances of those work refusals being successful on those facts are quite low.
So I'll take this one. Can you comment on a blanket policy requiring new hires to be vaccinated? Okay, so step one, you can never have a blanket policy if it doesn't make exemptions where human rights may apply. And so when we say blanket policy, if all we mean is a blanket policy that requires all new hires subject to human rights exemptions to be vaccinated, I see nothing unlawful about that whatsoever, subject to any new laws or regulations that may come up from time to time. And that would be something you'd want to have baked into your employment agreement. You would want to have your policy, of course, in your contract reviewed by Employment Council to ensure that there's no accidental stepping on human rights issues there or other grounds. But so long as you have the sort of release valves for those human rights valid exceptions or situations, and a process for determining the validity of an exemption, then you can create that rule and have a blanket policy for new hires. Absolutely. And the other side of that coin is, can you have a blanket policy that anyone who doesn't get vaccinated, subject to human rights requirements, will either be put on an unpaid leave of absence or have their employment terminated? Yes, you can have that blanket policy in practice too. But as Ryan said earlier, the question is, is that employee going to be entitled to something in exchange for that termination? So I know this wasn't a specific question, but it's sort of flowing from it, someone who doesn't meet the requirement. So let's say you hire someone and they tell you that they're vaccinated and they provide proof, and it turns out that that proof is invalid or it's fraudulent. What do you do? Well, at that point, you can probably terminate them, again, subject to the human rights exemptions for why they provided the proof in the first place. So just again, to answer the question simply, the answer is yes, subject to human rights, but you're going to want to have that policy vetted by council to avoid missteps. Ryan, we are in the HVAC industry, someone asks, and says, people are asking if our employees are vaccinated. So I guess we've got these people going in to install HEPA filters to keep people safe, and you know, not surprisingly, the clients want to know, are the people installing these HEPA filters vaccinated, or are they bringing the virus into the building? Can we decline to answer those questions from our clients? Do we have to answer our clients' questions about whether our employees are vaccinated, or can we say that we can't answer because of privacy concerns?
You run into an issue here that you know, is actually pretty complicated. I think if you, for example, you take a look at some of the public health unit language out there, specifically the London Middlesex one that speaks of like vaccination status of contractors. And in that case, the answer is crystal clear. You have a legally binding direction to do it. I think that I think that your risk on privacy is pretty low here. I think safety is going to trump it in all likelihood. I think you can and probably should answer those questions. I mean, certainly I've certainly seen and I've certainly drafted some pretty broad policies in that respect, particularly for larger employers. I think you're gonna face that as a reality. The obvious, it gets, and if you get, there may be certain situations, particularly if human rights arises as the reason for the exemption, then you're just gonna have to give us a call for some specific legal advice on it, because this is the kind of thing that comes up from time to time, particularly in the construction industry around safety and referrals and that kind of thing. It is a very tricky area of the law, and you know, we can't obviously give guidance on that. But in general, it's something you're probably reasonably well positioned to do.
Yeah, I mean, in another context, I have a number of clients that are in the temporary employment space, agencies and the like, and a number of them have clients who have said that the client is implementing a mandatory vaccination policy to apply to all employees, and that policy will be applied to external service providers as well, including agency employers that are sending temporary workers. And then the question arises, well, can the agency perhaps violate human rights law by complying with their clients' requests or requirements? The straight up answer on that is that if you don't own the facility, you can't determine, you can't force your client to take your employee as a temporary worker if they're saying we're only allowing vaccinated people on our site. As co-employers under human rights and employment standards legislation, it's probably a good idea to ensure that your policy, that the policy of your client or your policy as the agency has that release valve for human rights considerations and accommodation process. But aside from that, what I've done is essentially prepared a one-off sheet for agency employers to provide to their employees, which says, I acknowledge that certain work assignments won't be available to me if I'm not vaccinated, that in order to go to the site of a client that requires vaccination subject to exemptions, that my agency employer is going to require me to give them proof and to show that proof to the client, with appropriate protections for security and privacy sort of considerations. So that's sort of it's linked to this HVAC question, right? And so to the extent you have any concerns about it, providing a similar letter to your employees where they consent on the basis that the clients are demanding that someone be vaccinated may be a way to relieve that concern. But I do agree with Ryan in the ordinary sense. I don't think you're likely to face liability for sharing that on a broad level. But if you're sharing specific employee information, Joey is not vaccinated, then I think that's a little bit of a different question. You may need Joey's consent before you share that, and instead you would simply tell Joey that he's not going to go to that work opportunity unless he consents to you sharing that information, just to protect yourself. Okay, Ryan, when an employee submits a letter of medical exemption, how do we verify if it's a legitimate doctor's note?
Well, I mean, this is a problem that's going to be rampant around COVID-19 in light of the apparent ability of employees on the vaccine passport end of just being able to fake a receipt for admission into a bar or a restaurant or whatever. But I think this is a little different. It's obviously, I think the way you do it is you can simply call the doctor to verify the authenticity of it. I think that's I think that's a merit. You may need the employee's consent to do that, but that if you have a concern about it, I think you get the employee's consent in writing for the physician to confirm the note is authentic. And if the person's not willing to prove that the note is authentic, then there's probably good reason to believe the note is fraudulent, which would probably, in most cases, fraud is almost always just cause for termination.
Even if you're unionized, right?
And even then.
So I guess I'll take this one because it jumps off of something we were talking about before. If individuals were required to be fully vaccinated as a condition of employment, so a new employee is asked to sign off on this, but now that they're already employed, they're raising creed or religious exemptions. I guess that means perhaps they weren't fully immunized at the start and their employment commenced, and now they're saying I can't get my second shot because of some kind of an exemption. Can we use this as part of our argument to dismiss the request? Short answer is no. And so the law has been very clear for decades under human rights that if you employ someone and they, as a condition of their employment, have to be able to do certain aspects of their job, and then later on it turns out that when they represented that they could do these things, they actually couldn't do them all because of a human rights ground. There may be issues of honesty or dishonesty as to whether or not that's disciplinable misconduct and whether that gives rise to cause for dismissal. I wouldn't take that position without legal advice, because in most cases it won't be sufficient. But in terms of whether you may have an obligation to accommodate this request based on creed or disability post-employment commencing, the answer is you likely will have to go through the full process. You'll have to get whatever medical or religious affidavit evidence you think you need, and then adjudicate that as if it wasn't even part of their requirement in their employment agreement. Here, Ryan, is a good question for you, because I know you've been parsing local health and safety protocols for a number of clients recently. Do you have any advice or guidance on protocols or practices that differ between people who are vaccinated and people who are unvaccinated?
Well, I mean, in terms of protocols or practices, I mean, I think that people who are unvaccinated may very well be subject to a number of different restrictions than vaccinated people. I mean, the one that we've alluded to repeatedly is the testing of some kind, usually on a weekly basis. I mean, you may continue to insist that those folks wear a mask, even after perhaps masking is not required in indoor space, which may very well come to be the case at some point. There may be certain requirements around social distancing, and those are the kind of processes and protocols that will be that will be different than in other situations. And again, I think that if you're looking at implementing some protocols that vary beyond the very basics of testing, I think it would be useful to get some specific advice on your workplace as to what's reasonable or not. Because we don't want to trip up human rights issues, but you really have to remember that, rightly or wrongly, when you don't have a human rights exemption, there's no legal basis not to be vaccinated. I mean, short of, what flows from you not being vaccinated is a different story. And in fact, some might be said you're being given an indulgence to be allowed to be in the workplace at all.
Yeah, it's a bit like not wearing your seatbelt when you're driving, right? It's can you do it? Sure. If you object to wearing your seatbelt or stopping at a stop sign, well, you just don't get a driver's license. That's just how that works. There are certain privileges and certain rights, and they're not always the same thing, I guess. So we've got a question here. All right, so this is one that I think I'll handle because it deals with human rights. My industry is long-term care / retirement. We have implemented a mandatory vaccination policy, as was mandatory actually early on in that sector. What information does an employee need to provide to support a religious or creed human rights exemption? Well, the test under the Human Rights Code, based on the tribunal's determinations, is, and this flows right out of the Supreme Court of Canada's decisions at various times, they don't actually have to say that my religion expressly says, vaccinations are prohibited, right? Very few religions, especially the ancient ones, had vaccination as a concern. And so what they need to show is that it is that they, number one, that they truly hold that creed or are a member of that faith. So that's step one. They have to identify what the creed or faith is. They can't just say generally, I belong to a religion that says this is bad. That's not going to work. So identify what the faith is. They have to identify expressly that not only is it a central or important aspect of their faith, that they cannot, in their view, based on their faith, get the COVID-19 vaccine, but that they hold that belief deeply as well. So just because your faith says something, I'll use the example of myself. Probably you can guess by my last name that I'm Jewish. I don't keep kosher. And so although my religion says keeping kosher is something I'm supposed to be doing, I don't hold that belief. I don't think it's important, and I've chosen not to practice that aspect of my faith. So they need to tell you what their faith is. They need to tell you that it's an important prohibition within their faith, that they believe that it is a prohibition of their faith, and that they follow it, and that they believe there will be consequences to themselves in their faith, in what happens to their soul, whatever it is. There has to be some consequence within their faith for them violating this prohibition. If you have all of that, then that's enough. And again, these are very general brushstrokes. They don't have to get into specifics that it was in, this apostle said this. You don't have to do any of that, okay? In terms of what you're going to accept as proof, getting employees to fill out something in writing, which you don't spoon feed it to them, right? Because you don't want people with invalid objections that are just taking political positions to be spoon fed what you're looking for, and then just to give you what you're asking. But instead, just say to them, okay, so you've advised us you have a religious exemption. Please advise us what is your faith, and please advise us on what basis you believe that it would be contrary to your religion or your creed for you to get this vaccine, and then just let them give you their answer in writing. And if you need help with that, give me a shout. Any of the lawyers here can help you vet that to see if it meets the human rights requirements. But again, you're not looking for something that is chapter and verse. You're looking for something that checks the boxes, and in most cases, you're going to have to accept that representation in writing from the employee. So someone is asking, and maybe this is a good one for Ryan, talking about using testing. So I guess so people who haven't been vaccinated, they're asking regarding workplace testing, would it not be more prudent to require employees only to get tested upon the onset of symptoms? What would you say to that?
Well, I think that you have to look very carefully at what what the public guidance is in your specific circumstances. I think that the objection to that is that there's many people that it's a known situation with COVID-19 that many people carry it on an asymptomatic basis. So some might suggest that only testing people that have symptoms creates an unnecessary risk. That being said, I mean, again, I mean, like there may not be any magic to it in terms of your specific workplace, but I think that approach could leave you vulnerable because of that asymptomatic reality of COVID.
I've got one here. Can an employee demand some kind of financial consideration if the employer requires them to be vaccinated? So the short answer for that is, I think Ryan's already given that answer. Despite the prodding from employee rights groups and the commission, there is no legal requirement currently that employers pay for the testing if they're going to have rapid testing or other things going on, unless the regulation changes or the recommendations of the local public health authority specifically require it. A number of sectors have been given access by their local jurisdictions to rapid testing at little to no cost. And so you might want to look into that as to whether your sector has access in your local jurisdiction. I know, for example, in construction, in long-term care, in certain warehousing and distribution sectors, in food processing, you can get free rapid testing, is my understanding. Just contact your local public health authority, and they'll help set you up with the kits and the process. The other side of that, of course, is what if you're requiring the person not to be tested on site, but to go for testing? Can the employer require you to pay them for that time? The short answer is yes, but. So in Ontario, as you will be aware, there was a regulation that came out about 6 months ago where employees are entitled to take sick leave, which the employer must pay for, up to $200 per day based on what they would have earned, whichever is greater, whichever is lesser rather. And that requirement is for someone to go and get vaccinated, and if they suffer symptoms as a result of going to get vaccinated, or if they require time off because they have suffered from COVID, or they've been directed by public health to go off and self-isolate. And so there is a possibility that if someone says, I'm going to go and get vaccinated, and now I'm suffering from symptoms, a reaction to the vaccine, I need a day off, you may have to pay that person for that time off. I will say that employers that already had a sick leave policy that would have covered people for the same reasons as that leave prescribed, employees may not be allowed to double dip. So the requirement to pay them the 3 days arises only if there isn't already a policy that would cover them for that. And I'll also say that if the employee qualifies for that employment standards paid leave, that you can seek reimbursement from the Workers' Compensation Board, WSIB here in Ontario. But again, they will determine whether the employee was actually eligible for it before they determine whether to reimburse you. And I'll also say that you don't actually have to be registered with workers' compensation for coverage in general in order to apply for this reimbursement through their program. So sort of long story short, most employees are going to sort of push you, especially if they're in the lower wage earner side of things, to have to get tested at their own cost on a weekly or bi-weekly basis. That could be prohibitive for them. It might essentially be a barrier to employment. So you might want to consider whether that's something you want to do during the employee shortage, the labor shortage that Ryan mentioned. But on the other side of things, you may not have, subject to that 3-day requirement, any obligation to pay people for time off while they're getting vaccinated or if they suffer any symptoms as a result. Ryan, should an employer make the staff lunchroom off limits to unvaccinated workers?
Well, there we go. That's that becomes one of the flies in the ointment. I've asked this question quite a few times actually recently. And the answer to that question is it depends, I guess. Is it something you could perhaps realistically do, particularly if you can't have those employees socially distanced, and obviously lunch itself involves removal of masks and that sort of thing. So there may be certain circumstances where that's valid, but it's a tough one though, because that really is a very isolating restriction. If you're going to be in a position where you already have rapid testing as sort of a control measure, It might be something that you want to avoid, but I will say this could be one of those things where you get a work refusal on it. Though if one, of course, can infer that that the work refusal provisions would cover such a situation, and I suggest they probably wouldn't. But ultimately, it's something I would think about carefully and see if there's some other alternatives before I did it. But I can't say it's not permitted to be done.
Is it good enough? I think I'll take this one. Is it good enough to just ask staff if they have been vaccinated, or would you recommend that we get proof? Okay, so in your local jurisdiction, the recommendations of your chief medical officer of health may expressly say that you have to get proof. So if you believe that these recommendations are mandatory, and if in your local jurisdiction it says you must get proof, then the employee needs to be asked for proof. If you either interpret these recommendations as not necessarily mandatory in terms of all of the content of a policy, even if you have to have one, or if your recommendations locally don't expressly say that you must get proof or that you should get proof, then I think it's a judgment call. Ultimately, I think that if you are doing this for all the right reasons, which is the health and safety of that worker and others and the public, then due diligence requires you to take a step to verify, sort of as Tricky Dick used to say, trust but verify.
It was Ronald Reagan, actually.
Oh, it was Reagan. You're right. It was Reagan, wasn't it? Yes. So I think that that's an important lesson for employers to learn from a due diligence perspective. And so if you ask for proof of vaccination and someone doesn't give it to you, but they swear that they've been vaccinated, what would you do? Well, you'll treat them as like they're someone who hasn't been vaccinated. And so I think that's, in terms of checking that due diligence box, if you don't ask for proof, then you have to treat everybody and make all your protocols and your plans based on an unvaccinated workforce, even if you think that you can trust all of your employees.
Yeah, I just got to say, as the one who's sat here and read almost all of these local public health unit policies, almost all of them, as far as I can recall, all basically say you've got to have proof of not only of a vaccine, but one that's approved by Health Canada in many circumstances. As opposed
my
to
AstraZeneca vaccine will work, Ryan? It's the,
yeah,
not,
well,
not the best, but
yeah. Hopefully it does, for my sake.
Hey, they told me, the best vaccine is the one that's available to you, so I ran out and got it. Silly me. All right, so how do you deal, Ryan? I think you should answer this one as well. How do you deal with suppliers, like agency workers, or you call in someone to work on your HVAC, to go with the question we had last, in terms of ensuring those third parties are vaccinated?
I think this is sort of turning on its head the question that was asked earlier, really, about what do we do about customers asking for it. And this is, well, I'm the customer, what can I do? And I think the answer is the same, really. It's a little bit different in the sense that, I think you can just simply ask that any people that come be vaccinated. And that would be a condition, and that ultimately, if a human rights issue somehow arises, you can give us a call. But I think that most government, most entities are saying that, that especially if they have the bargaining power to say so, that, people that are coming have to be vaccinated.
So someone has asked, Ryan, you should probably answer this because it sort of jumps out from the first few slides you covered. Do we need to put a policy into place even if we aren't making it mandatory?
I think it's crystal clear on basically every public health guidance or recommendations that every one of them says that the employer needs to implement a workplace vaccination program, a vaccination policy. So you got to have the policy. What it says and what the recommendations for vary. But let's give you the example. In Toronto, Dr. Davila has said that these policies should consist of the following things. Workers can provide proof of their vaccination series approved by Health Canada or the World Health Organization. Unvaccinated employees to provide written proof of a medical reason from a physician or nurse practitioner that indicates whether the reason is permanent or time limited. Unvaccinated workers to complete a vaccination education course on the risks of being unvaccinated in the workplace. And unfortunately, these 3 bullets are missing the creed aspect of it, and that should probably be there. But that's an example. So yeah, ultimately the answer to the question, yes, you have to have a policy. What it consists of is subject to what the legal requirements are in your local public health unit and your own personal decision on what you're going to do. With the human rights part's not optional. The non-vaccinated part is where the non-exempt part is where the discretion of the employer comes in.
Thanks, Ryan. So I think I'll take this one. If an employee submits an exemption due to religious reasons, can you request that the head of their church or spiritual group submit support in writing, or would this be considered sort of an unlawful challenge to the employee? I think that's a judgment call, much like if an employee who submits a medical note that's so vague that you're not really getting the information that you need. If the employee has submitted something to you, and to use that example from before, if you're aware of no religious prohibition for someone who practices a certain faith that would prevent them from going to get a vaccine, you may have a valid basis for saying to the employee, we need more than just your say so. And so the question about whether that's always going to be available, or whether that is one too far, maybe is something you want to talk about with your counsel. In some cases it's going to be obvious. So I mean, again, there are certain faiths that we all know what the tenets are and what they're not. And so someone would have to be part of a very offshoot sect of a particular faith for the vaccination prohibition to actually apply to them, but maybe they do belong to such a faith. And so that would be a good example of a situation where you would say to them, look, we're not aware of your particular faith prohibiting vaccination, but we're prepared to validate this exemption if you get a letter from your pastor or whoever your spiritual leader, confirming that this is something that would violate your beliefs and of your faith.
Yeah, we just have to be careful about that, right? Because faith, it's so broad, right? Like we think of religion, we think of traditional organized religions that have an imam or a rabbi or a pastor or a priest or whatever. Those are the terms of religious leaders that are commonly thrown out. But there are some religions that have a very disorganized structure, may very well entirely be based on a book and have no leader, frankly. If you look at some sects that are like that. So you gotta be careful that we have to remember that for the purposes of human rights law, faith and creed means spiritual beliefs. It doesn't necessarily mean organized religions that are, as Jeremy referred to, sort of the ancient faiths that are common throughout Canada and throughout the world.
Hence the recommendation to get legal advice, not just because we're trying to make work for ourselves, but unfortunately, it may not be a yes or no. It may be a maybe.
Yeah, it really is. It's like most things that are discretionary in law and in life. It's a judgment call. You want to exercise good judgment.
So here's a question from a larger organization. So if I understand the regulation and these recommendations, which are basically local, from local public health units, an organization that has locations in different public health units may actually have to have a policy that applies differently in different local areas. Is that right?
The answer to that, it's a one-word answer, yes. That is in fact possible. It's frankly probable, but depending upon how strict your policy is. I mean, it may very well be doing it's kind of what some of my clients do that operate in multiple jurisdictions across international borders. The way they solve that problem is simply adopting the strictest approach as the policy company-wide. You may not want to do that, but yeah, the answer is yes. It may very well be that if you don't wish to follow the strictest policy and choose not to impose that across province-wide, then yeah, you may have to have different policies that have to be local, subject to the public health unit's direction.
Okay. So there's been a few questions like this, and I think I'll take it. It doesn't really matter which one I read. Essentially, the questions are about liability for employers. If an employee goes out and gets the vaccine because their employer has mandated it or strongly recommended it in their policy, and then they suffer some form of permanent ill effect or loss. Although it's rare, there will be some people who unbeknownst to them and their doctors, through some medical exemption, they suffer a severe reaction to the vaccine. It is possible, right? We had in the early days of AstraZeneca, there were some concerns about blood clotting, especially for women in certain stages of their life. And so the question is, can the employer be held liable And some of these people who have been asking questions have mentioned the fact that the law has expressly exempted the vaccine makers from liability in certain senses.
Yeah, it might be helpful if I weighed in on this one a bit, Jeremy. So
I'm not going to comment on that aspect of it, Ryan, but I think I'll comment on the standard, at least in Ontario, as it applies to whether or not someone contracts COVID or is injured. In terms of getting COVID at your facility, unless you're grossly negligent, if someone gets COVID or their spouse or their people around them get COVID, you can't be held liable for that. I'm not aware of that exemption applying specifically to employers that tell employees that they have to go and get vaccinated. But here's the thing. Nothing about you requiring someone to take a vaccine that is required by law anyways for you to mandate this for them is any part of negligence for you. You don't create the vaccine, you don't give them the vaccine. They're still consenting to the dose that they're receiving from a medical professional. I don't see any way from a negligence perspective or from a contract law in employment.
Jeremy, there's one other aspect of this, though, I think that is important to remember, and that is the workers' compensation aspect of it. WSIB, there's specific policy on this issue, says that if vaccine is a compulsory part of your employment, and then you get injured as a result of it, you can get compensation, which then, of course, flows. You can't sue in those circumstances. So
right, and the negligence is irrelevant.
Correct. Yeah.
As a no-fault system. That's a very good point, Ryan. So I think that probably answers the question better than I answered. I should have just given this to you, Ryan. So
yeah, there's a workers' comp question.
If they get an injury in and of the course of employment, and if they are covered by workers' compensation, then that's of course the case. If you're not covered by workers' compensation legislation, because you're not mandatory and you haven't opted in Ontario where that's permissible, then that may not be the case. But still, for those who are covered, that would be an instant answer and complete answer to that question. Got a number of questions here that kind of overlap. Ryan, if existing employees refuse to go and get vaccinated, and we have a mandatory vaccination policy, I would suppose, subject to human rights, can they be terminated with cause?
I'm sorry, what was the question? Like if they don't get vaccinated, there's okay. Yeah. The answer is it depends. I mean, ultimately,
vaccination policy, and they don't comply and get vaccinated, and they don't have a valid exemption, can they be terminated for cause?
Here becomes the question. That question is going to be answered by a court someday. It's going to be a fact-driven inquiry. It's obviously going to be an individual assessment. Is why did the person not get vaccinated? They're clearly not legally entitled to resist. The question then becomes would it have been more reasonable for the employer just to put the person on an unpaid leave until some unspecified period in the future where vaccine requirements are not there? My reaction is, and I'll say this is not a view universally held in the legal community, that if someone refuses to vaccinate, they do so without a human rights exemption, they do so at their peril. I think there's a decent chance a court will find that as just cause. That's my view. But there is an equally plausible argument to say that perhaps that either it's not cause or you should have put them on the leave. We'll wait till the Supreme Court answers that question, because undoubtedly they
will. All right, so got a question here about whether the human rights protections apply differently with respect to volunteers. So the short answer is no. So if you've got volunteers, they'll essentially be, from a health and safety perspective, that was cleaned up a few years back. Ryan can comment more about that. But from a human rights perspective, in general, they're going to be treated as would any other employee, even if they're not being remunerated per se. Ryan, do you want to comment on the health and safety aspect of that?
No, I don't think there's anything really to add. I think we probably just have time for one more question, I think. So.
Yep. All right, so let's see if I can find a really good question for you here. You know what? I believe that we have relatively, at least any questions that I think are going to be ones that we can handle today. So I think that ends our Q&A session. And thanks again to everyone who joined us. We had about 200 people at the sort of height of attendance, still quite a few of you here. So thanks again for slogging through it. Thanks again for joining us. Please do keep an eye out on our website, because as Ryan said, our annual conference, which will be offered on November the 8th, I believe.
Yeah, it's coming up on November the
complimentary fast full day session. So keep an eye out and register for that as soon as you can. And yeah, stay safe, everyone. Take care.
All right, stay safe. See you soon. Hopefully next time we see you, we're not talking about COVID. Bye.
Oh gosh, I hope so.